Well, again, thank you for coming out this morning. We are really excited to bring you this material as we went through and thought about, right? We all make assumptions that in businesses, we all know the things that need to be done. And yet this role of office manager, office administrator, right, gets, you call it a lot of different things in a lot of different companies, but you end up wearing a lot of hats. One of which is sometimes to be either chosen to be the HR person or voluntold to be the HR person, or you opted in. But there's still a lot of things out there that you've not necessarily had the opportunity to know and to understand kind of new laws and new things that are coming out. So not everything we touch on today will necessarily be legal in nature, although a lot of it does touch on those legal things you need to be careful of. But all of it should be things that will be easy for you to either just double check things that you're doing today or consider in terms of options of things you may want to go back and take a look at within the organization. The ideal here is that we're able to take, for those of you who have not met me, I started People Solutions Center 8 years ago. I came out of corporate HR, so my entire career has been in the HR space. I worked mostly, ironically, for large companies. I worked for Progressive Insurance for many, many years in their HR department and then as their director of recruiting. When I started the consulting firm, I really I started out thinking, oh, I'll do HR consulting for businesses. And I was really quite surprised to learn that in starting to work with smaller businesses, these kinds of resources just didn't exist. And so we knew we had an opportunity to bring information to you all on a regular basis and provide everything from capacity support, because when you're an HR department of one or not even a full HR department of one, you don't always have the capacity, but also bring you information and knowledge that helps just ensure you're trying every day to do all the things right. And this HR world is a little tricky. And so we've built our business focused on that small to mid-sized company being that resource that they need, either as technical expert, subject matter expertise, or sometimes just to get the heavy lift off of somebody's plate because they've got a lot of hats on any given day. And so today's conversation, I put together a top 10 list with a little couple of bonuses of things that you need to be aware of. And most of this is based on, when I was writing this presentation, I really sat down to think about what are the most common questions we get. And also when we start working with clients, what are some of the most common things that we run into that in our asking questions, they go, oh, I did not know that information, and thought what an easy way to help folks out by putting it all in one place. Quite honestly, this, as I was doing it, I had to figure out how do you get down to 10? Because I was running into more like 20, but it's a great starting point for many of you. So we're going to start with number 1. I'll take you through number 10. I will give you a little heads up because I like bonuses. There is a bonus number 11 that I think will be a great reference slide for you, and we'll look forward to you. We'll be happy to send that out afterwards. But I thought one of the most important places to start this year is the Fair Labor Standards Act, because this is in the middle of a very important change. So even if you thought you were doing this right all along, you might not be aware that the Fair Labor Standards Act is literally, there was a change in July and there's another change in January. And so what I'm going to do today is give you the high level on each of these 10 items. If there's anything that you're like, ooh, I didn't know that and I need more information, all you have to do is reach out to us. We'll be happy to answer more questions for you. But to get through 10, we're gonna keep moving along the way. So Fair Labor Standards Act, what you need to know today is there's a major change in place. It just started. One of the deadline changes was July 1st. There is another change coming January 1st. What's changing in the Fair Labor Standards Act is, first and foremost, there's always been a 3-pronged decision on FLSA. First, there was a salary test, and somebody has to make more than that salary cap in order to be eligible to be exempt, which means they don't get paid overtime. That's one test. The second test is a job duties test, meaning only certain roles qualify for that exemption. And if you don't qualify for the exemption, that role needs to get paid overtime. And then the third prong of the test, which is the part most people actually got right, was that you have to pay people salary, not hourly, in order for them to be eligible for overtime. The reason I put this at the beginning of our presentation is it is super important to know that A, there is a change, but B, many companies had this wrong to start with. So most of the clients that called us, we did a whole rollout in the spring about the changes we do FLSA audits for clients to help get them where they need to go and make recommendations. What's interesting about it is many clients called us and said, ooh, we're going to have a problem because the salary changed. And as we dug in and looked at things, they actually had a problem because they had misapplied job duties tests and they were having a salary change issue. So the new salary as of July 1st is $43,880. So if you have a team member who today is not getting paid overtime, but they're a salaried employee and they are making less than $43,888, it's time to you need to make the right changes to get back in compliance with FLSA. That number is changing again at the end of the year. Current word is, current law says it will go to $58,656. Now, I will tell you, there's some rumblings on the street that it may not actually go as high as $58,656. And this next statement is not a political opinion, and I hate to say it the day after everybody probably watched debates last night, not a political statement, but I can tell you that the election day could have a difference on whether or not the number on January 1st really jumps to 58,656 or whether they come somewhere in between. And so, but if you have somebody today on your team who is a salaried employee and they're not getting paid overtime, and they're making less than either of those two numbers, time to do an FLSA audit. Now, I put in this really big caveat. Do not walk away from item number 1 on our top 10 list going, oh, well, all my salaries are fine, so I may not need to do anything. The reality is this job duties test, that is the second prong of the FLSA test, is often misapplied. And so there are job titles and job duties that don't actually qualify to be in this category of not getting overtime, and you may need to change them as we go. So having somebody double check and make sure that you have actually applied your job duties test the right way is super important. And I will tell you, roles that are most commonly misqualified are situations where, for example, we use the term manager in the title, but the person isn't actually managing 2 or more people. Or we use we call somebody an administrative assistant, but they're not, and they're paid salary, so we don't pay them overtime. Most administrative assistant roles do not qualify as an exempt role, which means you have to pay them overtime. Many, many roles in these categories are impacted, so you really need to make sure. If you want more information on FLSA, if you just went, wow, alarm bells going off everywhere. Good news, 1, we have a recording of a full presentation we did earlier in the year, or just call us. I'd be happy to get on the phone and talk about what this all means. But number 1 is in the middle of a change, which is why we kicked it off there. Again, if you've got questions along the way, feel free to drop them. This is your sort of, for those of you who ever watched David Letterman, right? Otherwise we're going to keep moving and do our David Letterman version of this. So item number 2 on our top 10 list is OSHA. This OSHA is the Occupational Safety, Health and Administration Organization Act, and you are responsible as a business owner to follow OSHA guidelines. Now, there are often we find that companies don't know much about OSHA. You're typically trying to do everything right. You care about your employees, you want to make sure they're safe, but you don't actually know all of the OSHA rules. So here's one of the OSHA rules that we find folks often, hopefully, don't know about that happen. And somebody falls off a ladder or falls off the back. God forbid this ever happened, somebody died. Or if somebody suffers, and that just got a little funky for a minute. If someone suffers a work-related injury that results in hospitalization, amputation, or a loss of an eye, you have to call OSHA yourself and report it. It's required. Even if the person's not upset, even if you report it to work comp, even if you do all the right things, you are required to tell OSHA it happened. And not telling OSHA it happened means when OSHA finds out, first of all, there are fines. And second of all, OSHA, it sort of opens the book to everything. So OSHA will come out and look at everything you're doing and tell you, find all of the other things that you may not be doing exactly up to OSHA standards. So put this on your list. And while we all do safety training and it's super important, stuff happens. I had a client a painter, client in the painting industry, had an employee fall off of scaffolding. Luckily, he was following all of the OSHA guidelines. So calling OSHA wasn't a bad thing, but they still needed to call OSHA. Had a client recently that had an employee who was climbing out of the back of a pickup truck, decided not to put the bed of the truck down, right? Something your folks do all the time. Jumped out of the pickup truck, tripped, fell, broke a leg, ended up in the hospital for 2 days. There was a requirement to call OSHA. So again, just keep your eye out on this. Make sure you understand OSHA and you're familiar with it. It's probably one of the pieces I find most folks don't have official training on, but you're just trying to do the right thing. I always recommend to our clients that someone in your organization have an OSHA 10 certification, which basically means you've been to probably about a day and a half class on OSHA. And it gives you a really good understanding of like at least what to be watching out for. The example I used the first time I took OSHA 10 training when I started the business, because again, came out of corporate where we didn't know people, I didn't know people could get hurt at work. And I went to OSHA 10 training with one of my clients, and they were a cabinet manufacturing company. They had a huge warehouse setting. And when you were in the warehouse, there was a rolling door on each end of the entrance and exit of the building. I didn't think anything about it. They had the rest of the walls of the buildings had large shelves, floor to ceiling, that had all of their materials in it. We were sitting in the OSHA 10 class, and the gentleman teaching the class explained to us that you have to have an available exit door every so many 100 feet that people could get in and out of, and it wasn't obstructed. And the general manager and I that were sitting next to each other for my client, I looked at him and I was like, I haven't paid attention. Do you have doors? He goes, oh, well, we don't have to worry about it because we have the big doors on either end. Their warehouse was about slightly smaller than the length of a football field. He goes, but we have big doors on either end, so it doesn't matter. And the instructor overheard him whispering that to me and said, oh, by the way, rolling doors don't count. He went back from OSHA 10 training and went, we got to reconfigure our building. So again, there's little nuances that just help make sure you're probably not doing something that you intended to be like flagrantly off, but you need to make sure you're OSHA compliant. So OSHA hit a couple of questions for folks. I'm not surprised. One of them was, is in and out ER visit a hospitalization? No, hospitalization is considered under OSHA the overnight stay. So if they stay overnight, then you need to notify OSHA. If they just go to the hospital, you're good. And so it's an urgent care also does not count. In this case, the example I gave you where the employee was overnight, he broke his leg in a significant enough way that he needed to have surgery. And so he had to stay overnight for the surgery in order to do that the next day, which is what triggered needing to tell OSHA what happened. So, and actually in both of my scenarios, that's exactly what happened. They both fell, they both broke their leg, both needed surgery. So the OSHA 10 class is about a day and a half of training. You can always find these courses free. Your insurance company probably offers them. Sometimes there's a local chamber that will offer them. Easy way to get those free. There's a 30-hour class as well, which usually goes deeper. If you do design build, which means you have people doing more like construction type work for our landscape folks, I highly encourage you to have somebody both OSHA 10 and OSHA 30 certified. So typically what I suggest is like have your office manager or somebody that maybe isn't in the nitty gritty every day at least be OSHA 10 certified. So you have a general idea when you're walking around to look and go, that doesn't look safe, which is about what OSHA 10 will teach you. OSHA 30 will get a lot deeper. Find the person that's going to truly be in charge of safety and send them through OSHA 30. Again, all free, just good context for your insurance company. So on to item number 3, probationary periods. This is my favorite because it usually makes people go, what? So many of you, if you read your employee handbooks, may have the terminology of the probationary period, and somebody has to make it out of the probationary period either to be eligible for benefits. Sometimes it's just, we're going to just say you're in probationary period. Our recommendation, and the recommendation of most employment law attorneys these days, is to eliminate the concept of probationary period. And this is where everybody goes, I think I'm talking to a crazy lady. There's no way HR told me to get rid of the probationary period, but here's why we suggest this. And again, this is coming straight from the employment law attorneys. First and foremost, what does it feel like to start a job and on day one, when they go over the employee handbook with you, they say, so we're going to give you 90 days to prove to us that you were worth hiring. That feels pretty darn awful. So it's not a great start to a relationship that you want to be about building trust and telling people you're here to support them. But that's a fluffy reason for it, right? Those aren't always as important. The last of it is actually why the employment attorneys will tell you probationary periods are a bad idea. First and foremost, there's no reason for them. Probationary, you already should have an at-will employment clause in your employee handbook saying all of us are employees at will, and the employer can fire you for any reason at any time as long as it doesn't violate another law. So why do I need a probationary period to somehow give me the right to fire you more at will during the first 90 days? Doesn't make sense. The second piece, though, the problem is if you put it in place, it then puts this like artificial timeline around your at-will statement. So it actually can sort of throw off your ability to terminate somebody at will because you've said you're going to give them a 90-day probationary period. So if you fire them at will on day 70 because they're not doing well, they're like, well, you didn't give me another 20 days to get better. So it can really create this kind of drama for you. But in addition, and this is where we really see it get ugly, is what if you don't sit down before day 90 to say, hey, this isn't going well, or you have somebody on the fence, so you wait till day 100. Now the person goes, well, wait a minute, you said I was fine by like at day 90, I must have been fine. You didn't fire me. So why at day 100 am I not good enough? So it really messes up your employment at will clause. Get rid of it and just treat everybody like they're employees at will, which we are. Probationary period, you don't need a reason to speed up. And this is how companies used to use it. They used to go, oh, well, that means in the first 90 days, if they're not doing well, I can skip all of the other parts of the process. The reality is it doesn't actually buy you much at all, and it can mess you up on the back end. And the fourth reason to do this is the terminology of probationary periods comes right out of union world. And unions, right? Like we all would prefer, many of you would prefer not to have unions come into this space. In what is happening today in our workplace based on laws that have changed, it is easier and easier for a union to get certified in a company. And in that certification process, which is not all that difficult, the more you are using any terminology that is or practices that are common in union environments, the more likely you are to potentially have an employee be interested in taking that up, or a union coming in and suggesting it to your employees. So keep that in mind. I did tell you I was going to give you some bonus tips along the way. This one's super important and it relates to unions. The case law that changed one of the practices this year around certifying a union changed the rules so that a union could send you a letter saying, we would like to be recognized as a certified union for this organization. And it used to be that process was a long process. You got notified, you had time, you had to do the elections. There were all sorts of unfair labor practices you needed to worry about, but it wasn't that big of a deal. Or at least you had time to get ready for the fact that it could be a big deal. The new case law says they serve you a letter and you have less than 2 weeks to respond. And if you don't respond, the union is automatically certified. So make sure somebody's opening your mail and make sure it doesn't just sit on somebody's desk who thinks it is not true, right? Make sure somebody who knows what they're looking for, if they saw something from a union environment, from the National Labor Relations Board, like these are things that you need to be aware of and need to be paying attention to. If you ever get one, make a phone call. Don't start talking to people about it. Just pick up the phone and get help. But know that that is out there, and it's a really new change that organizations that aren't historically all that union, like haven't had a lot of unions come in, are just at a bigger, like they have to be more aware than they used to be. Item number 4 on our top 10 list is about payroll phishing. Phishing emails, probably many of you have seen one that looks like this. Hey, I need to change my payroll. I need to change my direct deposit. I actually just got one of these from it looked like it came from one of my team members last week. Ironically, she was on vacation the day it came through. And I just deleted it because I know that's not how we change payroll. So there's a couple of things you need to know about these kinds of emails. First of all, always make sure, don't ever answer an email that you don't think is real. So check the actual email address, not the part that just says, oh, this came from Adriana. Secondly, and most importantly, never, ever, ever accept a change to somebody's direct deposit via email, ever. People either need to put it in your HRIS system, which is your best option. A payroll or an HRIS system where they can go online and do it yourself, and you don't ever have to worry about whether you got the numbers messed up or anything else. It puts all the onus on the employee to do it online. That is your best practice. The other option, if you do not have an online HRIS or payroll system, only accept that in paper form. They have to walk in and hand you the piece of paper so that you know that it's the person who was intending to make the change, who made it. The problem with the paper form is now you have paper with somebody's bank account information on it. So again, ideal situation is get an HR system in place so that everybody in our payroll system, so everybody can do this online. Top 10, number 5, advertising and job titles. So you'll see in our top 10 list, we really jumped around to all of the different HR topics you might be interested in. So if legal doesn't help you out much, but recruiting does, we wanted to make sure you had a good background for it. So let's talk about job titles and recruiting. Many of you, when you pick a job title, you use the job title that's what you call this internal to your company. So client relationship manager may be what you refer to as an account manager, but that may not be what candidates are going to look for. So when you are advertising for openings, don't use job titles necessarily that are about what you think of the job to be called, but instead think like your candidates are thinking. Because one of the things that you need to know is when somebody goes into Indeed and starts searching, the first 2 words that they type in are what drives their search results. So if I type in the word sales as my first word, it's going to bowl everything back sales. If I type in client relation manager, right? How many things do you think out there are actually titled client relations manager? What are most applicants thinking? They're thinking that's called landscape account manager. So put yourself in the shoes of candidates and think, if I wanted this job, what word would I be typing in? And don't worry about what you call them once you get hired. We can talk about that in the recruiting process, but if they never know you're hiring for it, they won't ever end up on your team. And so this job title information is really important. Some of the ways to check it out is take the job title you plan on hiring for and do your own search in Indeed and see, like, do I even get results back, right? We had a client that wanted to use a title, a logistics coordinator title, for a role that was really more driver and procurement. And we were like, we can't use logistics. Like, you'll never end up, that's not what somebody looking for logistics isn't going to want to do this job. So we used a different job title. And it was funny at the end, they're like, I think we just got really lucky that we got this person, because they were really surprised that like this job came up for them, because this isn't what they would call it. And I was like, absolutely. But they had the exact background you were looking for. So they were searching for the right thing. So again, put your candidate hat on, not your employer hat on. Also, if you are in the landscape, again, remember, first two words matter. So if you're looking for an account manager, don't just run account manager, because you're going to get thrown in with all of the other kinds of companies that might have an account manager, marketing, advertising, things like that. Put the word landscape in front of it, particularly if you care about a particular industry. If you're in construction, right? Like, put those types of things in, and it actually broadens your search, because anybody who types something starting with landscaping might be more likely to get it to pick up. Another good example, I just had this conversation with a client recently. They were looking for what they are referring to as their chief revenue officer. How many people, even at this high of a level job, do you think are typing in the word revenue when they're looking for a job, right? It's just not happening. So instead of chief revenue officer, we will be advertising sales director or sales vice president. And you'll notice I didn't use director of sales, because in this case, I care more about the sales experience than the level. So sometimes we will put in like sales director and then hyphen some other word if we need a qualifier. Put it at the end, not at the beginning, if you need to increase your boost. And also know, with all of these job boards, you can change them. Once it's posted, you can still edit your job title. So sometimes you got to play with it a little bit along the way. All right. Again, if you have questions, feel free to drop them in. We'll have time at the end as well, but we are moving on to item number 6 on our top 10 list. And this one is harassment and discrimination reporting processes. This is something that we really see as a challenge in small to mid-sized companies. We all think it won't happen to us. Particularly, I see this in family-owned businesses or second-generation family-owned businesses. Everybody feels like family. So of course, this could never happen to us. The reality is you have to have the right policies in place. One, to make sure that your team members always know the expectation. Sometimes the fact that we have a family environment where everybody's just having fun can go too far without intention. But it doesn't really matter what the intention was. It matters what the impact is. So when we talk about harassment and discrimination, particularly the harassment side of it, we need to know, and we need to be clear with employees, that there's 2 types of harassment. There's the quid pro quo, this for that, sleep with me or you'll lose your job. And there's the other type of harassment, which is just people interacting with each other in a way that makes it a really uncomfortable environment from a sexual perspective, or related to items that are discriminatory or sexual in nature. Either of them are illegal. Either of them, if you don't have a great way for people to report that it's happening, are really expensive. And the difference is quid pro quo only has to happen once, right? We think of hostile work environment as something that has to happen over and over and over again, right? Like an everyday kind of thing. I will tell you, we had a client that 2 years ago had a situation where maybe 3 times somebody had made an inappropriate joke to one of the ladies on their team, and it was drastically inappropriate. So it was out of line. And it came from husband and wife owner. It came from the husband. So really inappropriate, right? Because now you're talking about the owner doing it. Cost a lot of money in terms of a full year salary they ended up having to pay just to settle the case. The reason I tell you that is, first of all, you need to make sure you have these policies in place, that you train. In fact, some states require training. There's about 11 states at this phase that require annual training for harassment to make sure that this isn't happening in the workplace. And you have to have a really great way for people to report. Because if you have a harassment claim that comes up against you, what they have to prove is, first of all, that the harassment occurred. Secondly, that the company failed to take the appropriate actions. And one of those appropriate actions is that a complaint process existed and is documented in a way that it is a process that a reasonable person would trust that the complaint process was going to happen. This is why it's so important for smaller businesses, because if you have fewer people that somebody can go to, and all of those people are, especially in family businesses, related to one another or really good friends, the chances that a reasonable person would trust that you could report it and nothing bad would happen goes down automatically. So small to mid-sized companies have to have good processes that you go, you know what, if somebody had a problem, they truly would use that process, not should, but would. And then the third piece is you actually have to follow your process when it exists. So what do you do about this? First of all, viable complaint procedure under the court rulings is that the employee can expect that it will be kept confidential, that there will be no retaliation, and that an investigation will actually happen. Those are the three criteria that the courts or the EEOC or anyone else that gets into the investigation would look at. Then we have to say, who should they tell? We always suggest an owner, their manager. Sometimes if the office manager is somebody that, again, is in a position that could address the issue or has the support to do it, the office manager is often one of the people that we would list here. Human resources is somebody you want to list here. And this option of a confidential alert line gives you as a company that one more layer of protection. So what is an alert line? An alert line is a system in which somebody could call anonymously to report that harassment or discrimination had taken place. That alert line is set up. So again, it's anonymous. It is monitored. Like in our case, our alert lines are monitored by a third party, us. So if somebody leaves in a number or leaves a message, that message goes directly to us. It's tied to the company, so we know where it came from, but then we can do the investigation. The reason these alert lines are so important, major corporations have these all the time. And it was one of the things that when I left corporate world and came to work in consulting for small businesses, I was floored. I'm like, well, who would you go to? Like, where are people supposed to tell? Because you don't go in an owner's scary. I mean, I have an HR company. My team should know that it's safe to come to me, but they might not feel comfortable. It's my baby and it's too small. So the courts have said if you have a confidential alert line that is set up appropriately and managed by an organization that you could say you should be able to tell people, call this, it will get taken care of appropriately, that automatically they will dismiss those cases. So that's a sort of a get out of jail free card. You gave them a viable option. They chose not to take it. Essentially what they do is send it back and say, you have to follow the internal process. So these confidential alert lines, they're not pricey. And most people are like, oh, but I don't want my employees calling them all the time. I will tell you, think of it like an insurance policy. It's the thing you have out there that you never, ever, ever need to have, right? But having it saves you a ton should you ever have an actual issue. Again, everybody needs one, particularly though for family-owned businesses. It's really critical. All right, item number 7 on our top 10 list. Job descriptions. Why do we have them? Job descriptions are critical. Not only do they have, first of all, they have a ton of use in terms of reducing your legal risk. So it's probably not surprising that you're talking to somebody about HR and they're going to say you need job descriptions. The reason they reduce your legal risk is you need them for workers' comp. So here's what people don't realize. If you have somebody out on workers' comp and they have an injury and they've been told that they can do light duty, or that they can do some of the job, parts of the job, but they can't do all parts of the job, you can actually give them the job description and tell them to take that to the doctor, and the doctor can specifically tell you what they can and can't do, so you don't end up in the middle of a really awkward medical conversation or having to figure out what is or isn't possible for them. You don't want to put yourself from a work comp perspective. You do not want to put yourself in the position of being able to being the person to make that determination. So we give these to you, have the person take it to the doctor. And if your job descriptions are well done, it will give them everything they need to give you the guidance you need. And we'll talk about if they're well done in a minute. If you have 50 or more employees, these job descriptions become really important when we're starting to talk about family medical leave. Particularly on an intermittent basis, this becomes key. So if you're 50 or more people, need these job descriptions for legal purposes. If you are, if you're covered under the Americans Disabilities Act, which my bonus slide will tell you at the end, but if you're covered under the ADA, job descriptions are an absolute must, and there's some key things you need in there. And then that Fair Labor Standards Act that we talked about back in number 1, also really critical for figuring this out, because the job duties test is tied to the job description. So somebody who reads your job description should be able to look at it and go, oh, I see how they applied the job duties test. Now I know that it's okay, that they got the FLSA exemption correct. So that's all the legal reasons. But the first 2 reasons on this slide are actually the important reasons. Really great job descriptions, when these are done well and they are not viewed as a compliance tool, great job descriptions help set expectations, and they are the key to a great coaching conversation. I can't have a coaching conversation if people aren't all on the same page, not only in terms of what their job is supposed to be, but how much time they're supposed to spend doing certain parts of the job. I'll run through that in a minute. So I keep saying really great job descriptions, right? So here's a couple of things that you want to make sure on your really great job description. First of all, obviously, you have to have your job title. You want to have the job duties, but I'm going to give you in a minute a clarification on what I mean by this. I do not mean job duties in terms of the list of 15 things somebody is responsible for. There's actually a really great way to make job descriptions better than that. You want to make sure they outline the required qualifications. If being able to drive is a requirement of the role, that needs to be super clear. If they have to be able to climb a ladder or do certain skills, you need to make sure that's in your qualifications. And then there's a section called work environment. And the work environment section is tied directly, again, if you're required to follow the ADA by law, you need this work environment section, because you need to be able to say the person needs to be able to lift 50 pounds, or they need to be able to walk across uneven surfaces, or they need to be able to climb a ladder. Whatever it is, you have to be really clear on that. And then the last part of your job description is your disclaimer and your signatures. Your disclaimer needs to say, hey, this person has seen the job description, and more importantly, that the company has the right to change the job description at any time. And then we have them sign it, so we have it in our systems. But here's what makes a job description truly great. Remember, I said, don't make a job description about the 15 things somebody is supposed to do. I've seen somewhere it's a list of the 100 things somebody's supposed to do. Great job descriptions actually break somebody's job down into what are the top 3 to 5 buckets of priority that this role is responsible for. For example, right, if I'm hiring somebody for, say it is an account manager role, there's a difference. I could hire an account manager for one company and another company, and they're going to look super different. They're not going to, same job title, 2 different roles and responsibilities. And there's a big difference between a role that is supposed to be 60% client relations, maybe 20% of working with the crews, a little bit of quality assurance, and then some updating of systems. But what if instead of being that type of role, what if instead 60% of this is about going out and getting new business? Same job title, very different qualifications, very different responsibilities. And so when we say, here are the big buckets, and then we put those bullets under them so that we give clarity, we change the way our job descriptions work, and more importantly, the conversations we can have around that. because I might be a candidate who would love a job that is 60% client relations and customer service. But if you made it 60% sales, ooh, I'm never applying for that position. So taking this approach to your job descriptions also helps from a legal perspective, because think about, right, if, for example, quality assurance means I have to go out and walk people's properties, and I have a work comp injury, and the doctor says I can't walk on uneven surfaces for, right, that's my one accommodation during this workers' comp piece. Well, according to this, there's might only be about 10% of the job I can't do. So light duty might be an option. If my restriction is something else, though, it might be a bigger deal. I had laryngitis for 4 weeks this summer. If I had gone to a doctor about it, they probably would have told me, don't talk for 4 weeks. I can't do my job, right? That doesn't work. And so understanding the percentage of time that it is sets the employee up and the doctor up to give you much better outcomes. So from a legal perspective, from a coaching perspective, from a hiring perspective, this approach to job descriptions is really key. All right, we're gonna keep moving. Again, if you've got questions, feel free to put them in the chat. I also will take them at the end. Item number 8, discrimination policies in handbooks. So your employee handbook needs to have a discrimination policy. That should not be a big surprise. That, trust me, there's more to it than that. But there's some verbiage that we often find incorrect in employee handbooks. And so this is just one of those, like, go back and break yours open. For some of you, that may mean go back and dust off the cobwebs, but go in and take a look at it. First of all, it needs to say that discrimination based on either somebody's actual or perceived either that they actually are in the protected class or they are perceived to be in a protected class. And that perceived part is really, really important. So, for example, if I have an individual on my team who I would perceive to be a member of the LGBTQ community, so I believe them to be part of a protected class under their sexual orientation, it doesn't actually matter if they are part of the LGBTQ community or not. I just made them a protected class. Interestingly enough, make that easier to think about. If, for example, I have a team member on my team who I perceive to be pregnant, but they are not, and I make decisions based on my assumptions that are negative, that have a negative impact on that employee, it doesn't actually matter that they're not pregnant. I perceive them to be, and therefore they fall under the protected class. So it's super important that that be in there, and that more importantly, you follow that. You can actually create a discrimination claim for yourself, regardless of whether the person is protected or not. This comes into play often when we talk about sexual orientation or age or pregnancy. Like, those are the circumstances. Disabilities. People perceive disabilities all the time, and your disabilities, your ADA requirements, perception is part of that. Some other things that we find are often missing from companies' discrimination clauses. First of all, you need to make sure that in your list, long list of protected classes, sex or gender is listed, particularly making sure that you've got the qualifications in there for pregnancy, childbirth, and pregnancy-related conditions. You need to make sure gender identity or expression, which means includes transgender status. This is a legal requirement. It does not matter whether or not it aligns with your values or you don't agree with somebody's sexual orientation or personal preferences. Under the current law, this is a requirement in your discrimination clause, and it's often what is missing. And the last one is sexual orientation. Gender identity or sexual orientation are probably the top. Like, and when I open a brand new employee handbook, first thing I look at is their discrimination clause to see if those two things are in there. And yeah, it's about 60% of the time they are. Most of the time we end up having to update that piece of it alone. So it's a quick hit, a quick check, but make sure you understand that these are covered and protected classes, they not only need to be in your handbook, but you need to make sure that your day-to-day practices are following those. Number 9, background checks. This one is usually a big aha moment for many folks, because you may not either may not be doing background checks today, or you're doing them and you're doing a little bit of stuff all on your own, like social media and things like that. But most of you are doing them and may not have had much training in what's required. So here's a couple of things to know. First and foremost, the Fair Credit Reporting Act. The FCRA, or the Fair Credit Reporting Act, is the law that governs what companies can and can't do as it relates to background checks. And there's 2 really important pieces to the FCRA as it relates to background checks for employment purposes. The first one limits greatly the extent to which you can use someone's credit as a criteria for employment. We only run into this about once or twice a year, where an employer is trying to actually get the credit report as part of the background check. If you are, you have to be really cautious that you have verified, that you really can substantiate that the credit report part in particular is critical to the job. So examples of roles that might be, if you are a small business and your controller has significant access to bank accounts, you could probably make a case for this. If, on the other hand, you have an accounts payable clerk who is writing paying checks by invoices, but somebody else is really has control of the account themselves, you can't run their credit report. You can run a background check, but not a credit report, and those are 2 separate pieces of it. You can't find out my actual credit score is the key. The second component of the Fair Credit Reporting Act is a bit broader in its application and impacts a lot more companies. If you are using a background check today to make a hiring decision, so somebody has to clear a background check. First and foremost, I would tell you, if you're not doing this through an actual vendor, you need to, because there's a lot of legal requirements that make background checks really sticky and messy on what you can know, what you can't know, what's reportable. Do not use things like CaseNet, or I Googled them and this came up. You are fraught with legal risk when you do that. Instead, go with a vendor who will run the background check, and use a vendor who actually follows all the laws. And I'm sorry, but not all background checks do know the laws and they don't follow them. But if you get something back on a background check and you use that information to turn the candidate down. So for example, if I run an MVR report for a candidate who needs to be able to drive one of our company cars, and I decide based on that MVR report, you know what, they have a DUI in the last 3 years and my insurance company won't cover them, so I can't make the hire, you have a requirement to notify that candidate through a process that the Fair Credit Reporting Act calls the pre-adverse and adverse process. Your background check vendor should be able to do this for you at no additional cost, but if you don't know to tell them to run it, they won't know to do it. And so you need to, if you don't know what this pre-adverse adverse process is, if you've never heard of it, but you know you've turned people down, this is a great reason to phone a friend and give us a call. We'll talk to you about what that should look like, or phone a friend and call your background check vendor and find out what their process is for making this happen. The second piece of advice I give on background checks is around limiting your risk in general. So first of all, make sure that only a very limited number of people, if you are running background checks, only a very small number of people, and those people who have a business need to know and the ability to keep it confidential, should ever view what is on somebody's background check. You never know what will come back. Things come back all of the time. And sometimes what's on that background check, once you know, you can't unknow, right? But some things that come back, you can't unknow it, but you also can't use it as part of your hiring decision. So it's a really awkward spot to be sitting in. So keep it tight. Keep it to just maybe the office manager, just the owner. We have some clients where we are their HR person. We're the only people that see their background check. So nobody on site ever knows. And we make the yes or no decision, and we consult when we need to. But it's one of the ways to protect yourself, to make sure that information doesn't get out. Also, I will tell you the other reason to do this is quite honestly, states call things really horrible. Like sometimes you get a misdemeanor, you're like, oh my gosh, I think they killed somebody. And you're like, no, they didn't. So I'll give you a perfect example. The state of Texas has a misdemeanor called theft by check, which sounds really awful, right? You think, why would I ever hire somebody who did anything that's called theft? Theft by check means somebody bounced a check. You know what? I know few people in my lifetime who have bounced a check here or there, and they weren't bad people, and I wouldn't use it as a hiring decision. But if you read it and it says theft by check, you might be daunted. The second piece to this is avoid social media. Do not go out on social media and search for people to see what's on their profile. The reason for this is back to that concept of you can't unknow what you already know. And once you look, you cannot prove to somebody that that did not have an impact on your hiring decision. So if you find out that somebody has a disability, or somebody is gay, or somebody is married to somebody, to an individual from a different race or whatever, or you see a picture of them with a 50th birthday party balloon behind them, you can no longer say you didn't know. And oftentimes, unfortunately, when we look at people's social media things, our unconscious bias goes all astray and we start drawing all sorts of bad conclusions about people. So A, it's just not fair to them. And B, again, you're going to get yourself into all sorts of legal issues where you know something that you actually aren't legally allowed to know. And now if you use that information for a hiring decision, you're in a really sticky spot. So keep it in mind. The other piece we suggest in the last and final part about background checks is we actually recommend in many cases bypass the reference check process. Now, a couple of you just probably heard that and went, huh? The HR people are saying this? But here's the reason why. First and foremost, when you do references, for the most part, you're asking the person, who do you want us to call? Well, unless they're crazy, they're only going to give you people that they want you to call because they would say good things. Also, if they are following the people that you're calling, if they do give you somebody and an employer to ask, you are literally making a phone call and going to ask somebody to give you information. That the second part of this is, I would tell you, never, ever, 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 under any circumstance, give a reference for one of your employees. You give dates of employment, job title, and that's it. Whether they were your star employee or whether you fired them, that's all you give ever. So why would you start calling other employers and asking them for something that you should never be giving out yourself? And again, on the rare occasion that you might get somebody who will tell you something that you find out about an employee that is a problem, often the thing that they tell you leads straight to something that would be covered under your discrimination clause, and you can't use it anyway. But boy, you can't unknow it. So check, verify dates of employment, get those pieces right. But reference checks are kind of a myth. They're kind of a myth in HR world that they actually keep you from making bad hires. Have great hiring processes and check out the things you can, but trying to find stuff out other ways really does not, gives you a false sense of security and doesn't really help you. It can hurt you in the long run. That's the one, trust me, I know number 10 just made a lot of people a little uncomfortable. So I get it. It's just a suggestion. It's a recommendation. Number 10, unfair labor practices. We're going to dive back a little bit to the earlier conversation around the union situation and what's happening there. But unfair labor practices are things that if you are found, it's covered under the National Labor Relations Act. These are things that if you do these things and somebody is trying to form a union or get a union certified, they can come back and say, by doing this, you actually were trying to keep the union out. And oftentimes what we find is these things are things that you've done not with any thought about the union. So for example, if you tell an employee, don't ever discuss your compensation with anyone. By the way, go check your handbooks. This might be in there. If you have that in your handbook, or you have ever said to somebody, here's your compensation and don't talk about it to anybody, you've actually committed an unfair labor practice. Even if the reason you didn't want them to talk to Susie about it was because you didn't want Susie to be upset that you're making more money, doesn't matter. This is how companies used to keep people from being able to talk to the unions about how much they're making, which made it difficult for unions to get a foothold with employees. So they made it an unfair labor practice. Regardless of your intent, your impact gets you into all sorts of legal trouble. Also, check your employee handbook for the billboard and solicitation policy. So if you have a policy that says, right, you can't leave material, nobody can ever leave materials out in your break room related to buying, selling, or promoting anything. But yet, when everybody's children are selling Girl Scout cookies, there are Girl Scout cookie order forms all over those tables. It could turn into an unfair labor practice. So you want to be really clear about what your policies truly are about where people can leave materials about non-work related items. And the last one is one that I really found like rampant, particularly in the landscape industry a couple of years ago. I think it's kind of coming back to normal, but many of you, whether it's landscaping or other industries, out of the goodness of your heart and trying to do the right thing, have created employee committees where the folks on this team are supposed to be the voice of the rest of the team, right? Maybe it's 2 or 3 people that are kind of the voice of the rest of the team. It is a great intent, and there's a way to put that in place that doesn't cause you a problem. But you have to be really smart about how you do that and what you call it. Because anytime you start saying, hey, this person, I had a client once who said, oh, well, we have an employee liaison. I said, well, what's the employee liaison? Well, if the employee ever has a complaint about the workplace or their work conditions or that they're in trouble and they didn't feel good about how it was handled, they can go to the employee liaison, who is a peer, not their HR person or their office manager or the owner or their manager, and that person can bring it to management on their behalf. You just created your own union, and it's not good. So be aware of these kinds of things. If you're going, employee focus groups and ways for people to like have engagement ideas, employee engagement committees are great, but they can't be around things like workplace conditions, safety, compensation, discipline. They have to be about things like, how do we make it fun to be here? And then you usually, as long as you structure them the right way, you're fine. But be leery or careful on the other versions. So your bonus item, number 11, because we hit our top 10, number 11 is a slide that I think you will find helpful. It is employment laws by the numbers. So based on the number of employees you have, here are the federal laws you are required to follow. Now, you may have state laws that are different. So you always need to know your state and your local laws as well. But the top half is things that everybody is covered under. Your Fair Labor Standards Act, your NLRA, your National Labor Relations Act, your equal pay, your immigration reform, which is your I-9 work, your OSHA, occupational safety and hazards, and your fair credit reporting. Applies to everybody, doesn't matter how big or small you are. The next jump at the federal level is really 15 employees. And once you hit 15, you start being covered under Title VII, the ADA, the Age Discrimination Act, and the Pregnancy Discrimination Act. Now, some states have a separate law. Typically, it's called the Human Rights Act law, like we have a Missouri Human Rights Act law, and it starts covering employers for many of the things that are covered under that list of 15 employees. Starts covering them at the state level when they're less than 5. So you've got to be really careful about where you fall based on your state and which state you're in. Once you hit 20 employees, you have to start worrying about COBRA, which means if people leave, you have responsibility. If you have benefits and you would then have responsibility for them to be able to continue those benefits after they leave. And once you hit 50 employees, you pick up the Family Medical Leave Act, the Affordable Care Act. Here's the key. If you got 50 employees, it all matters. There is not a law out there you're not going to be covered by. So again, we're happy to share slides with folks after, but we thought this was a nice sort of piece of reference. It's not every law, but it's a whole bunch of them. So I will take questions, a couple of things as we wrap up to make sure you know. First of all, we always offer to folks that take time out of your day to engage with us and get this great information. We do offer free HR strategy sessions So you can just email us at our hr@peoplesolutionscenter.com. We'll meet with you and kind of go through if there's a specific topic you want to talk about based on one of these, or if you just need a like, hey, I figured out we've got a lot of holes and we need some help. We can just at least give you an idea of here's the things you need to be thinking about in the next year to 3 years so your HR strategy can match your business strategy. Especially if you're growing, thinking about what might be down the road for HR law is important. The second piece I do want to let folks know, we've had some emails going out this week. We're starting our advertising for this, but this fall we are launching our very first HR Foundations class. So it is a workshop series. It will be 8 workshops based on several different HR topics. It won't be webinar form. It will be interactive for the people in the class. It will be lots of here's some information, but here's case studies. And trust me, we've seen a lot, so we can write some case studies. But it will be fully encompassing for folks that have HR responsibilities, but maybe haven't ever had the opportunity to really dive deep into this HR practice. So if you would like information on our HR Foundations workshop, simply email us at hr@peoplesolutionscenter. Nicole will follow up with you and get all of those details to you. I always also take this opportunity. This is the time of year where we are launching our leadership development courses for the winter. So we have leadership development courses from every level, from foreman through owner, for folks that are looking to learn more about how to be great coaches and leaders. They're workshop series that run through the winter season. So lots of opportunities to learn and grow. Feel free to ask questions. Nicole, if you could turn off the recording in case people have questions they want to voice, I'm happy to stay on for